Hi, good morning or good afternoon if you're in Europe. My name is Anna Melander. I am the Director of Marketing for Volpe Koenig. We're really excited about this webinar because we're teaming up with AWA. This is our first joint webinar and we're very excited about it. Just a couple things. So there's some handouts. The presentation and the oh my gosh, there's two handouts, and so please feel free to download. It's the presentation and the evaluation form. If you are in the United States, your attendance will be reported to the Pennsylvania CLE board, so you just need to stay on to the end of the webinar. Everyone, regardless of jurisdiction, will receive an email of their attendance, so you can, if you are in Europe and if it works, you can take that certificate of attendance to your jurisdiction and see if you can get continuing legal education. I'm not sure how that works, but in the US, you will be reported. Everyone has entered in mute, but if you have questions, the presenters would welcome them. Go ahead, pop them into the chat, pop them into the question box, and they will take questions as they go along. So with that, you know what, I'm going to let the introductions, I'll let Jeff do the introductions. I'm just going to turn it over to shareholder Jeff Gablicki. Go ahead, Jeff.
Thanks, Anna. Today we're going to be discussing patenting artificial intelligence and software-related inventions, and we're going to be discussing them both from the US perspective and the European perspective. On the US side, the presenters are me, Jeff Gablicki, and then Jay Halt. We've both been involved in this space for a long time, and Jay hasn't only been prosecuting in the software space, but he's also an inventor on a patent for a software-related invention. So he's an inventor and a prosecutor in the space. So he knows the ins and outs here. And also on the EP side, we have Magnus Johansson and Frederick Lannemere from AWA. And we've been working, Volpe Koenig has been working with AWA for, I think, close to 20 years now. It's been a great relationship. And these two, Magnus and Frederick, they're really working in the trenches there in European practice, getting these software patents. So it'd be real interesting to all of us, including Jay and myself, as to their perspective on the European patents. Now, the presentation is going to be a pretty simple flow, and the big picture, it's going to be an overview of artificial intelligence, which will be fairly short, and then we're going to get into the US perspective, and then we're going to get into the European perspective. With respect to artificial intelligence, it's generally just defined as making intelligent machines, but I think today it's kind of progressed a bit where it's essentially now more like software and or hardware that kind of mimics human intelligence. And when most people talk about artificial intelligence today, they're typically talking about these deep learning neural nets, which can really simulate kind of some fundamental human type thinking and kind of replicate it. Just some basics about like these deep learning neural nets is that they're just kind of mathematical constructions that kind of mimic the way the human brain works, where the human brain has neurons, which are essentially simulated in software, it's like a gating function, and then they have synapses, which connect the neurons together, which are essentially replicated in software typically as weighting functions. So essentially, a neuron will fire, the weights will go through the synapses to other neurons, and then if it's sufficient enough, then the other neuron will fire and start another cascading. And this kind of replicates how the human brain works. Now, just an overview on how machine learning will typically work, where we essentially have the artificial intelligence, but it has to be trained. And a typical way to train it would be with supervised training, where you have this data lake of information. And this could be like customer information, where it gets in there for like targeted advertising, or I'll use a more simplified example here, like a more classic example would be the Oregon housing prices, where the data lake will have information on prices of houses, sale prices of houses today, the number of rooms, the number of square footage, the location, and essentially from that information, certain features like such as the number of rooms of the house, the square footage will be put into the artificial intelligence. And based on that, it'll predict an output. And based on the error of that to the actual house price, it will readjust the weights within the artificial intelligence. And then as it goes through more and more learning, the predictions will become more accurate and more accurate. Certain things with this artificial intelligence model here is that there's growing concerns more with this data lake the data lake here, where for like social media companies, they gather users' data, and that essentially becomes the data lake. And Europe is a bit ahead of the U.S. here, where they have this general data protection regulation, GDPR, as most people refer to it, which is protecting the user's data there. And a lot of what's happening in Europe is progressing over to the U.S., where California is starting to enact regulations similar to that, and it's going to other states. So this is kind of like a growing area. And after the artificial intelligence is trained, you essentially will then just put in the inputs and get the output. And essentially the artificial intelligence has learned. Now, typical cases where artificial intelligence comes up with inventions would be a simplified view is here is that I have a prior art system here, which has A, B, C, and D. And then somebody just says, oh, I can just replace D with the artificial intelligence. It might be faster, it might be slightly more accurate. But typically in this case, and Jay's going to go into a lot more detail on this, that this is going to be difficult to get an invention of, just kind of using artificial intelligence as an improvement to an existing system like this, unless there's some unexpected improvement, just like not faster or slightly more accurate, or some unknown capability that was added to it. And this is a typical situation that you hear a lot from people where people try to get an invention on, especially in the past, where you had a system of A, B, C, and then a human had to do something to fill it out, and they go, well, I can use the artificial intelligence, learn what the human does, and then essentially replicate that here. So essentially, I have my invention is A, B, C, and I have the artificial intelligence replacing the human, and it's obviously has advantages because the artificial intelligence may be more accurate than the human. It is likely faster. It doesn't require you to hire a human, but then the problem is that it's going to be extremely difficult to get this type of invention in the U.S. under Alice, and Jay will go into more detail on that. And I'll turn it, and then just the overview of the U.S. side here is that I'm going to turn it over to Jay shortly, where he's going to go through the Alice 101 issues, essentially what is statutory subject matter and the challenges here, because those really impact software inventions and artificial intelligence greatly. Then I'm going to get into some of the divided infringement issues. For example, in the US, and my understanding it's different in Europe, that we're really driven towards a single infringer, and typically the software artificial intelligence inventions can involve multiple parties, so that becomes a complication. So it becomes an issue for the claim drafting. And then I'm going to get into, if time permits, into the nonce words, the Williamson case, where that's again, in my understanding is that generally in Europe, means for language is acceptable and generally preferred in most cases in Europe, where essentially in the US, using means for language is really frowned on. It has a lot of issues, and if we have time, we can get into that. but the Williamson case kind of extended that means for language to situations that aren't, to words that aren't just means for, such as element or module and other such words. Now I'm going to turn it over to Jay to discuss the statutory subject matter.
Okay, thanks, Jeff. The Supreme Court set forth a test for patent eligibility, and really the Section 101 of the Patent Act provides eligibility requirements for patent. It's very broad, as you can see, and really was not a problem until fairly recently. Next slide, please. So that recently came in the form of case Alice Court v. CLS Bank, and the Supreme Court set forth a framework for analysis for patent subject matter eligibility. Next slide, Jeff. So it's basically a simple overall simple two-part test. The first part of the test is to see whether or not the claims are directed to a patent ineligible concept. So is it a law of nature, is it a natural phenomena, or one of these judicially identified abstract ideas? Next slide. So the second part is there something more? So you might have an abstract idea, but if the abstract idea, if the claims include subject matter that put the abstract idea into some other form or format, which I'll get into, then the claims can be patentable. So overall, it was a very simple two-part test. Next slide, please. So obviously, the USPTO is bound to follow the rulings of the court. However, just like in all rulings or laws, there's a lot of room to interpret that ruling. And once a PTO reviews the ruling, it has to put in place guidance for the examiners. Next slide. So this is where the U.S. PTO has come out, and it's essentially a three-part test with some sub-steps that I'll get into, and unfortunately they're frequently changing. So we couldn't just have step 1, 2, 3, 4, and 5. We have steps 1, 2A, prong 1, 2A, prong 2, and 2B. But essentially what the test for patent eligibility looks at, and is highlighted by these three red boxes, are first look into the statutory categories, then we look at the judicial exceptions, and then we look at the inventive concept. Next slide, please, Jeff. So the first step is the statutory categories. So so is the claim directed to a process, machine, manufacture, or composition of matter? Since claims are typically, a method for, a device for, or a composition consisting of, this is a fairly low bar to meet. So we usually don't run into problems regarding that. Next slide, please. So then we have step 2A, and there's two prongs to this step. The first prong is the claim directed to a law of nature, a natural phenomenon, or an abstract idea? Now this is really very broad. So the PTO has set forth guidance, and the guidance is in the MPEP section 2106. And for our European colleagues who are not familiar with what the MPE is, it's the Manual of Patent Examiner Procedures, and it provides guidance for the examiners to analyze the inventions. And in this particular case, 2106 gives a lot of guidance in this area. So it's really a very helpful use, because this is what the examiners are going by to examine the inventions in the AI and software space. So we refer to this a lot, much more than I ever have in my career, for guidance. Excuse me. So the examiner must determine in this step whether the invention is directed to one of these groupings. Next slide, please. And these groupings are, is it a mathematical concept? Is it a mental process? Is it a certain method of organizing human activity? So the problem with this is, as you can see below, the U.S. Supreme Court realized that at some level, everything rests upon, one of these concepts, one of these constructs. And the Supreme Court cautioned that if you take this too literally, really there would be nothing that's patentable. So essentially the court said, be reasonable with your interpretation. We have found that, unfortunately, this, particularly in the beginning, this was not always, this warning was not always heeded, and we often find that the examiners go too far in this direction. So, for example, a practical application of this, whereas you might have a claim, and the claim, even though we resist putting in mathematical formulas, the claim might have a mathematical formula. Sometimes examiners will point to that mathematical formula and they'll say, see, this is an abstract idea, and they'll pretty much gloss over or ignore the rest of the claim. So that's really very problematic, and then you have to dig out of that hole. Next slide, please. So prong 2 of step 2A is, even though you have this this abstract idea that might have been in one of these judicial exceptions, these groupings, is it characterized in such a way that turns it into a practical application of the exception? Now, that might be a bit confusing, but the next slide will kind of explain that. So what the USPTO looks at is, like, what is a practical application? So you might have a way of accessing a spreadsheet, or a way of accessing data that's quicker and more streamlined. If you can characterize it in such a way as that is the improvement to a function of a computer, like the speed of a computer, then that turns this ineligible, something that a human would do to access, a portion of the memory of a computer. If we can argue that it actually improves the speed or functioning or the efficiency of a computer, that's a practical application. And I won't go into detail with all this case law, but if it's if we can characterize that in such as the examples in 2106 set forth, then it's found to be patent eligible. Now, there's not as much case law on this because these cases are not brought up much anymore. But as Jeff alluded to, there are a lot of early software patents or AI patents that took what was done previously by human activity, whether in a financial, fintech application or some other computer type application, and just implementing it on a computer, applying it via computer. That doesn't cut it anymore. There has to be something more. Next slide, please. So step 2B it's very similar to step 2A, prong 2, and oftentimes people just gloss them over. But this step is very similar to the prior step, but it also looks at whether there are elements of the claim that represent well understood routine or conventional activity. So as Jeff alluded to, if you have something that's an abstract idea, it's incorporated into a claim that has other well understood routine and conventional activity, but you get unexpected results that also can be found to be patent eligible. So that step is very difficult. Once you get to this step, if you're relying upon this, most of the case law has found the claims to be patent ineligible. So next slide. So what do we do with all of this? So even though the case law has really been all over the map, the good part is that we have been able to find some common threads and have been able to get claims allowed even despite all these hurdles. So the first practical consideration is if you have claims that are software or AI related, NPEP section 2106 has numerous examples of all types of claims that were found to be allowable. So even though we don't like to do this, we have at certain times argued with the examiner and set forth almost in a claim chart comparison format. This is the example and this is our claim. And even though they're different, our claim tracks that example. So it makes it really hard for an examiner to say, well, if your claim is aligned very well with this patent eligible concept, then it's pretty convincing to an examiner that your claim can be found to have patent eligible subject matter. The next thing, of course, it's easier for the examiners to allow a claim when it's characterized as an improvement to a computer, implementing via machine, or transferring it to a different state. Okay, next slide. And recent case law points to the importance of the specification to back up your arguments. And we found it interesting that a lot of the recent case law sort of alludes to a European approach. So there are cases where setting forth a technical, like in the specification itself, where applicants have set forth a technical solution to a technical problem. Say, hey, there was a technical problem and we solved it. Or discussing the advantages of your invention over the prior art. Or describing improvements to one of ordinary skill in the art. Next slide, please. So I won't go over all this case law, but it's interesting to note the courts have said the specification sets forth, specification supports claims because the specification had a technical solution to a technical problem and solving identified weaknesses in prior networks. And then the next case talks about where the prior art fails and how the applicant succeeds. So these are aspects that if you tuck them away in your specification and the examiner is not so sure, we can go back to the specification and say, hey, look, here, there was a technical problem and we found the technical solution. Our European colleagues have been telling us to do that for years and we have resisted, but now might be the time to finally go in that direction. So finally, the preamble, which is, sorry, Jeff, next slide. The preamble, which is previously considered to be non-limiting, may now be important. Next slide. And I'll point to this one case in particular. It's Wisner v. Google, where there were 4 pending continuation applications. They all had the same specification, and their claims were all similar, but the preambles of the claims were significantly different. And 2 preambles basically pointed to the invention, like a system for solving X. And like right there, a method for enhancing digital search results for a business in a target geographical area, fairly explicit. And the court pointed to those 2 preambles and said, hey, look, this claim is specifically directed to this, even though The preamble previously was not given much patentable weight. The preamble now might be. So all of these practical suggestions, you don't have to implement them all, but given your particular case, one or more of them might be helpful. And I would say from my practice and doing this over the last decade, in this, handling this particular problem, I think one of the best pieces of advice that I would give is talk to the examiner, because the group with technology art units unfortunately handle these things a little different. Some art units are really, really tough. Other art units are easier. And even groups within the art unit handle these differently. So what I have done before is when I get a rejection, I call up the examiner and say, hey, how serious or how strongly do you feel about this rejection? And oftentimes they'll admit, look, I had to raise this rejection. We have to raise it. You have to rebut it. So we have it on paper. So at least there's an argument of why this is patent eligible subject matter, and then we can move on. So in those particular cases, as U.S. attorneys are often want to do, we use less words. And in other cases where the examiner says, no, I really think this is an abstract idea, where we really might need to dig down, align with those examples, use a lot of these different things that we have put forth. So I would say the best thing to do is talk to the examiner, see how strongly they feel, and then implement your strategy. So with that, I will turn it back to Jeff.
Thank you, Jay. We're running a little over on the U.S. side for time. So what I'm going to just do here is briefly touch on the divided infringement and the Williamson issues here. With respect to the divided infringement, that in the U.S. we really want to have a single infringer, and for the software-related inventions today, they can get very complicated with all the parties involved. Like here we're showing there's an end user, Mary, who's using her laptop to use a service, and the information goes to like Wi-Fi to an internet service provider, and it goes to a cloud service provider who's servicing the application, and that service provider could be then in turn getting information using other service providers, and then possibly getting data to do the processes from another service provider, data storage provider. So essentially, from the US side, if at all possible, we want to claim either the software on the laptop, or we want to claim what's going on a virtual machine in the cloud service provider. We don't really want the interaction between the multiple parties, because then that creates multiple infringers, and then we have to go to another argument for infringement, such as inducement or contributory infringement. And one other thing to note, that when you're in the cloud here, it's typically distributed processing. So you just have to be careful, because if it's like one processor, it could be moving between these virtual machines, what's actually happening in practices. So you might just want to have some leeway claiming like multiple processors if you know it's a cloud-based invention. With respect to, I'm going to get into the means language, because that's a big contrast between the US and European practice, where means language is acceptable in Europe and generally preferred, where in the US, the means language, or the 112F as it's currently done, is a big issue. And the big reason for that is because in the statute itself, it has that under 112F that the terms shall be construed to cover the corresponding structure, material, acts described in the specification and equivalents thereof. And essentially the problem is if you get a means for language type construction or 112F, that you're going to likely get a narrower construction, or you risk a narrow construction, because they're going to look to the specification for the materials and acts and structure, and you'll get that. I mean, a positive is that you can get the equivalence thereof, but more likely than not, you're going to get a narrower construction. And just to kind of illustrate kind of like the US practice there versus European, this isn't like a stock. This isn't like the stock market here. This is actually the use of means plus function language in the U.S. And you can essentially see that it was kind of commonly used up until 1990, and then it just took like a nosedive, like a cryptocurrency, under the current standings, where nobody generally uses it anymore. So generally, you want to avoid means plus function, and under Williamson, it's a bit tricky because it then that extends it to what was typically terms like element or member. Element, like those could be construed as means plus function because it went from a strong presumption before Williamson and until now, where essentially it's a rebuttable presumption. So it's going to be, you have to just be careful with how you're phrasing claims in the U.S. And I'm going to turn it over to Magnus for the EP side. Let's see, how can I do this? All right.
So, thank you, Jeff. And I will see, do you see my screen? Good. I will compact my material a little bit so we don't run over time here. So what I will go through in the beginning here is what the EPO calls computer implemented inventions. And then my colleague Frederick here, he will go into the details of AI inventions. Let's see if we can make this work. So first, let's take a look at the legal framework. And some of you have perhaps seen this a million times, but I will just run through it fast so that we're all on the same page here. This piece of the law may be the origin of much of the confusion regarding patenting in Europe. So if we look at the top in Article 52.1, we can see that there are 4 distinct requirements that must be fulfilled in order to get a patent granted. And the first one is that we indeed have an invention within the meaning of the law. And then it must be new, it must have inventive step, and it must be susceptible of industrial application. And interesting enough with Article 52 is that it requires that we provide an invention, but it's not defined what an invention is. But if we look at the top, we can see that the phrase "in all fields of technology" at least say that we somehow need an invention that is related to technical aspects. And then Article 52.2 gives a list of excluded things, and among that we can also see programs for computers, which is the fuzz. And and in order to emphasize that it's only pure non-technical or abstract concepts that should be excluded, Article 52.3 at the bottom indicates that computer programs are excluded only if they relate to such subject matter as such is the term used. And here perhaps is where the confusion starts, because as such is a very vague term, and it has therefore been the subject of numerous case law decisions over the recent years here in Europe. But as we will see soon, it eventually resulted in a requirement that an invention must have technical character, as they say. So before continuing, I must say that the term software patent itself is not legally defined in the European Patent Convention, because software as such is commonly understood as abstract concepts or ideas that are to be implemented on computers using computer programs. However, the EPO, they grant patents related to what they call computer implemented inventions, or CIIs. And this term is used all over the place. And I will get back to that in a couple of minutes when we look at some examples. And at the bottom, you can see a definition you can find in the guidelines for examination, where they say that basically a computer implemented invention involves the use of a device, such as a computer network, or some other programmable apparatus. So then what's the fuzz really all about? Going back to Article 52, we just saw, this is sort of a visual representation of the top part of that article. And the first hurdle to the left is, do we have an invention within the meaning of the law? And that hurdle is quite easy to jump over. As soon as you add basically any technical means, a computer, for example, you will jump over this hurdle. And the second hurdle is novelty, which I think is the same more or less in all jurisdiction, at least the one I know of. Any new feature, technical or non-technical, will get you over this hurdle. However, the problems may emerge when we come to the third hurdle, which is inventive step, because it is here that nowadays the EPO really scrutinizes the technical content of your claims. And the last hurdle at the right is more or less never ever a problem. So let's take a look at the inventive step, because there is where the action is. So looking in more detail on inventive step, just to define the terminology, there is a difference between claims that only comprises technical features, or classic inventions, if I call it that, and claims that also include non-technical features. And the EPO calls the latter mixed type inventions. And the EPO more or less always applies the problem solution approach. So in order to handle this type of mixed type inventions, the EPO has created a modified, if I may say so, a modified problem solution approach based on a case from the boards of appeal at the EPO labeled T641 of 00, which is also known as the Comvic case. I will get back to that also. So based on the Comvic case, the problem solution approach has grown a bit here in Europe. For those of you not familiar with the problem solution approach, the black text we see on the screen is what we can call the classic problem solution approach for claims only comprising technical features, and the blue text reflects an adaptation to mixed type inventions. And in short, the classic approach is to first, we select a suitable starting point, called the closest prior art. And after that, we determine the differences between the claimed invention and the closest prior art. That is, what features are missing from the prior art compared to the claimed invention. And then in point 5 here, we formulate an objective technical problem on basis of technical effects achieved by these features. And please note here that when we formulate the objective technical problem, it's based on the technical effects and not on the technical features as such. That is, the problem that is generalized such that it does not include any pointers to the claimed features. And finally, in point 7 here, we determine if the claimed solution is obvious to the skilled person when starting out from the closest prior art and considering the objective technical problem. And in the modified approach, since we now also have non-technical features present, it is adapted so that before the objective technical problem is formulated, we also determine the technical effects of each feature to see if it really makes a technical contribution or not. So in point 4, if DPO come to a conclusion that the differences does not make any technical contribution, we have no inventive step, simply because inventive step can only be based on technical features. But in point 5, we then look at only the technical features that are in your claim, whether or not you have non-technical feature present. Only the technical features are used for formulating the objective technical problem. And then to the funny part, perhaps for many US practitioners, is point 6, where the differences that do not make a technical contribution, they are, so to speak, given to the skilled person, in particular as a constraint that has to be met. So putting differently, everything non-technical is considered obvious and may be used as a framework for the skilled person's development of the closest prior art. So looking at what this really means, this is the convict case, a bit simplified, of course, but on the right side, we see the claimed invention. It related to a cellular network, GSM in this case. It had subscriber units or mobile phones. And these mobile phones had SIM cards with 2 or more identities on the SIM card. And the claim also defined that calls could be made selectively from either of these 2 identities on the SIM card. And also that costs are distributed in accordance with the identity selected. That is, the invention basically enabled you to use one single SIM card in a mobile phone to make both work calls and private calls, and then separate the costs for the different calls. And on the left side, we see that the prior art in this case shared features 1 to 3 with the claimed invention. That is, the differences in the middle included features 4 to 6. And however, in contrast then to the classic problem solution approach and formulating the objective technical problem, the board in this case concluded that merely because some features uniquely appeared in the claim does not automatically exclude them from appearing in the formulation of the problem. And in particular, where the claim refers to an aim to be achieved in a non-technical field, in this case, distributing costs, the aim may appear in the formulation of the problem as part of the framework for the technical problem that is to be solved. In particular, as I said, a constraint that has to be met. So in this case, the last 2 differences were not considered to be technical differences, but rather financial or administrative improvements. So the last 2 features became part of that framework for the technical development, and the problem to be solved by the invention was formulated by the board as basically how to adapt the known GSM system to the left to allow a user selectable discrimination between calls for different purposes or by different users, with the argument that the technical professional would, in a realistic situation, receive knowledge of the cost distribution concept as part of the task information given to him. So he received all the non-technical stuff, and then they asked him, what would you do technically with this? And of course, given that problem, the 2 or more identities was considered as obvious in view of the prior art. So the take-home message from this slide is that make sure that your claims, as far as possible, comprises technical features, and that these features solves a technical problem. That also is derivable, of course, from the description. So it's a little bit looking like you're going over to in the US right now. And just briefly, these are the cases referring back to the convict case, 400 or so. So we can see it from case law that this way of handling mixed type invention is definitely here to stay. So wrapping this up a little bit, although the convict approach is well established, it suffers from a lack of legal definition for technicality. And it means that during examination of mixed type invention, which software inventions often are, when breaking down the test for technical character from the level of the claimed subject matter as a whole to the feature level, the examiners quite often deliberately or unintentionally interprets the claims in a way that is dissociated from the technical context of the invention. So in practice, this often leads to rather arbitrary or artificial separation of technical and supposedly non-technical features. So the objective problem solved by the invention is hence often formulated as non-technical problem, for example, relating to business or administrative schemes, while alternatively a technical problem could be formulated. So with this in mind, when drafting a computer implemented invention application for the European scene, you should make sure to, if possible, formulate a technical problem in the description. And I know that in US practice is quite different in this respect, or at least has been. And you should do this even if the main focus of your invention relates to, for example, a business method. And also think about the technical effects your claimed features has and describe these in the application, since that will form a basis later on for formulating the objective technical problem. And if your invention includes parameters or variables and such like that, make sure that these are described in clear technical terms. For example, if a value is used, is it based on a physical quantity, etc. And finally, with the risk of kicking out an open door here, make sure to describe how the invention is implemented and how any values are obtained, since this may provide you with arguments should the examiner consider your invention to be, for example, an administrative routine or the like. So in general terms, regarding software claims, by including any technical means in your claims, you will pass the first hurdle, is it an invention? But the rest of your claimed features, if they consist solely of non-technical features, you will never pass the inventive step hurdle, because your claim must, the features of a claim, I should say, must contribute to the solution of a technical problem. And over the years, I've seen applications that look more like a sales brochure for a gaming or business scheme rather than a technical description of an invention. And I can say this hardly ever passes over the inventive step hurdle. And there are, of course, nuances to all this, where you may end up in discussions whether or not a feature really contributes to the solution of a technical problem or not. But I should say that's a topic for a separate webinar, and we absolutely don't have time to go into that in depth right now. So finally, just going to give you some simplified examples. If we look at the top, we can say that we have a claim, for example, defining a system which divide orders of buying stocks among buyers based on the buyer's credit ratings. And this will most likely be considered as non-technical, since it is a financial problem to evaluate the buyer's credit ratings, and it will get rejected. And on the contrary, a claim defining a system which divide orders of buying stocks among buyers based on the speed and reliability of the internet connection of the buyers is arguably technical, since it does relate to a problem which with a business person isn't really concerned. It's a technical problem. And likewise, if we have a claim defining a user interface which improves the readability of texts in the UI by using specific different colors for the text and background of the text, will most likely be considered to relate to a non-technical aesthetic or design problem. While a claim defining a UI which improves the readability of text in the UI by considering the resolution and the frame rate of the display is arguably at least technical, since it facilitates a continued human-machine interaction by resolving conflicting technical requirements. And then there is a whole bunch of claim language that is acceptable at TPO, and I will not go into detail about this. It will be provided in the handouts, which will be sent out after this webinar. But I want you to bear in mind that software claims, if I may call it that, actually protects the steps performed by a computer program, that is the algorithms. And this corresponds to a method claim. So a method claim is the normal starting point for protecting software inventions in Europe. And once you have a nice technical method claim, then you can use this as a base for your apparatus claims and computer programs claims, etc. So for example, just looking at the top here, we can see we have a method claim formulated, for example, as a computer implemented method comprising steps A and B, etc. And to make sure, I must stress this, you must make sure that always mention a piece of hardware in your method claims, because that piece of hardware always is a technical means that give technical character. So we can jump over the first hurdle we saw in the slide earlier, and also make sure that the rest of the steps, of course, solves a technical problem. And then drafting the apparatus claims is quite straightforward, just by referring to the method claim or recite an apparatus comprising the means for carrying out the steps performed by the method. And the same goes for computer program claims. You do exactly the same. And finally, you can do the same also for computer readable storage medium or data carrier claims. So with this very brief rush through the European patenting of software, I hope we're now ready to go over to AI inventions, which my colleague Frederick will tell you about. And I will switch this over to you so you can do your presentation, and hopefully you get it on your screen.
Yes. I hope you will see my screen eventually. Perfect. Okay, now we heard first a little bit about AI in general from Jeff, and now a deep thought about computer implemented inventions in Europe. So now we combine this into AI inventions in Europe. In one way, I could lean back here and rely on what Magnus already have told you, because in most cases, people will consider AI invention in the same way as software inventions, as we just have discussed. The AI as such is non-technical. So AI inventions will be examined by the EPO similarly as computer implemented inventions. So in that way, you might hear me saying some things that Magnus already have said, but now with an AI focus. It all comes back to you need to have technical character that provides a technical purpose of the claimed features. So different parts of AI that could be patentable. Abstract AI models and algorithms are sometimes called core AI, which is the basic computational models and algorithms within the AI functionality. That kind of features would, in general at least, not be patentable in Europe, because it would be seen as mathematical nature and thereby not be patentable. However, when it comes to how the AI is applied in applications and implemented, there is a lot of space for patenting the technology. But also when it comes to the training algorithm, how you train your AI model, it could be patentable. The steps of generating the training data, for instance, and so on. So if we go one step further and look at different categories of applied AI inventions, the first one, marked in blue here, is more or less what Jeff talked about in the beginning, where you take for instance, a machine learning model and to replace, for instance, a manual work or a step that it previously have been implemented in a more common way. So you do the same thing, but now you include an AI part or a machine learning part. That would probably be difficult to patent unless you, as we discussed, you have some unexpected technical effect. Going forward with the green one here, where you, for instance, use a machine learning model in an embodiment to implement something, but where the AI is not really crucial, that you could realize it in some other way, but you have selected a machine learning model to do it. That could of course be patentable, but in that sense, the AI is perhaps not the crucial part. It's not the part that makes up the patentable invention. So the main focus would rather be on the third one here in red, where the AI is the really crucial thing that makes this invention being possible. Typically, it could be like real-time camera effects or technology for self-driving vehicles or robotic surgery or things like that, where the invention is only possible because of the AI being implemented. So there's a lot of different ways of how to put this into claims. But as we discussed, the AI invention is treated similarly as the computer implemented invention. So the way of drafting claims for an AI invention is rather similar to what Magnus discussed earlier. You have the different kinds of product claims and process claims. A few things that sticks out here from when talking about general computer implemented invention is of course the trained model, for instance, that you could claim, but also possibly the data structure, how a neural network is built up to in a specific implementation. And when it comes to process claims, it could be methods for generating a training data set to use in training a model. Of course, an operating method on how to operate the AI model, but also the training the model using specific training data, and also using the training data, of course, for analyzing data, for instance. One important thing here is it comes back to a little bit to what Jeff talked about earlier. Also, it's important to separate the different parts, especially when it comes to the training of the model and application of the model, to have them separately drafted in the claims. And to more specifically exemplify here, typically you draft the AI invention in a independent claim as a computer implemented training method or operating method or similar wording. Then when it comes to the apparatus and device and systems, it's a means for carrying out the method and the steps of the method, being the software or the AI that performs the functionality. The computer program product, of course, comprising the instructions for the carrying out the method, could also then be applied as a trained machine learning model, trained in accordance with a training method. So a few things to think about. Also very similar to what Magnus talked about earlier. Important things to think about regarding the technical effect to include the technical applications, how to use it, the hardware requirements, and the technical considerations that is necessary and was necessary to come up with the solution. It all comes back to the technical purpose of the invention and how you provide the technical character to make sure that the feature you have will be defined as technical features. Another important thing is that you don't try to treat the AI as a black box that magically puts out something when you put in something else. You need to be concrete in how the algorithms work and the reason for picking them, and be clear in that. And also when it comes to the training data, it's important to include details about the training data that provides the functionality of the AI. The AI will function in a specific way based on the training. So we're approaching the end of this webinar, and the end of the AI part. Thought we could look at two short examples of granted AI patents in Europe, and first of them is a method here for calculating an acoustic score. And we see in the third line here, calculate an acoustic score of a window by using a deep neural network-based acoustic model. Then I have some further steps and a step at the end for recalculating the acoustic score, for instance. But it's a good example to see how the neural network, in this case, the model, could be included in the claim. And the technical purpose here is for calculating an acoustic score. And you see also briefly mentioned at the end how the claim structure was built up with an electronic device, referring back to the method of claim 1, and also a computer readable medium having the instructions for the method, so on. The second example is a training method instead, where you train by means of a neural network a neural model, as you see in step B. So you receive some operational data and use it to train a neural model. So this is specifically a training method for an AI invention. And also you have the claims 13 and 14 there. You see the apparatus in form of a controller adapted to perform the method of claim 1 and a computer program product. So to wrap up, as a short summary, the AI inventions are more or less computer implemented invention and are treated the same way. It's all about the inventive technical contribution. That's the important thing also when it comes to AI inventions. So in that sense, European patents are possible for technical applications, implementations, and training methods when it comes to AI. And also, as I said, no European patents for the black box mystery AI functions. So thank you for this. It was all for this part.
Thank you, panel. Thank you very much. If there are any questions, go ahead, pop them in. I'm not seeing anything come through, but I do want to thank our distinguished panel for a very good webinar. And I do know that they have plans to join up again next year. And our Vulpecanics webinar series will continue in 2023. You will be receiving emails on that. Again, you can download the presentation and the evaluation form. That would be great. And before we sign off, is there any final words from our panel?
Thank you for letting us speak.
On behalf of Vulpecanics and AWA, happy holidays, everyone, and we will see you next year.
Thank you.
Thank you.